Hi, everyone, and welcome. Thank you all so much for joining us today for this community webinar about the Connecticut Parentage Act. As you may know, the CPA updates Connecticut law to recognize the diversity of families in Connecticut and ensures that all children have their legal parentage established regardless of the circumstances of their birth. The law was signed by the governor in June and will go into effect on January 1st, 2022. We are here today to celebrate and learn more about the law from two extraordinary advocates and leaders who made this historic law possible, Doug and Polly. My name is Melina, and I have been involved with advocacy for the CPA as a law student and as a board member of two organizations that promote LGBTQ family equality. And I'm very excited to be moderating this discussion today. Before Doug and Polly introduce themselves, I'd like to let everyone know that this webinar is being recorded. Additionally, we have already received questions from some of you that we will be answering. If you have any further questions, of course, please add them to the Q&A box and I will ask them to our panelists. I'd also like to remind our viewers that this is legal information to educate the community about the law and not individual legal advice. For individual legal advice, please contact GLAAD for referrals and support. All right, why don't we hear from our wonderful panelists? Doug and Polly, will you introduce yourselves? Let's start with Polly.
Great, thank you so much, Melina. My name is Polly Crozier. My pronouns are she, her, hers. I'm an attorney at GLBTQ Legal Advocates and Defenders, and GLAAD, as you may know, promotes justice on the basis of sexual orientation, gender identity and expression, and HIV status in New England and nationally. I'm so thrilled to be here today. Was so thrilled to be part of the coalition that passed this bill that I think will have such a tremendous impact on families in Connecticut. And I am also by training a family law practitioner, and I'm also a non-biological parent of two lovely children. So I connect to this in so many ways. I'm thrilled to be here, and I'll pass it off to Doug.
Great, thanks Polly, and thanks Melina. I'm Doug Nejame. I'm a law professor at Yale, and I worked on the Connecticut Parentage Act with Melina and Polly and a bunch of other organizations and individuals around the state and around the country, some of whom are on this call. So just want to express my gratitude to everyone for all the work you did to make this possible. It's really a law that is going to make people's lives in Connecticut better and help families in our community in immeasurable ways. And so we're so excited to be on the other end of this, anticipating the law going into effect and being able to talk about the great things that it's going to do for families in Connecticut.
Thank you both. And it really is a gift to hear from these two, and I'm really excited for the conversation. Before we dive into the content of the law and what this actually means for families, I'd also like to thank all the members of the We Care Coalition. As Doug said, several are on this call, and of course, Representative Jeff Curry and Senator Alex Kasser. Their legislative leadership was really instrumental in passing the CPA in the House and the Senate unanimously. I also want to emphasize that the passage of the CPA was the product of an incredible grassroots movement that combined the work of legal luminaries and community leaders. And I'm so grateful personally that I was able to play a small role in that historic movement. Working on this legislation was particularly meaningful for me as a child of two fathers born through assisted reproduction. 25 years ago, when I was born, the world looked a whole lot different than it does now. My dad's confronted a very difficult and stigmatizing legal process to secure parentage rights for me. And for several years, I was not legally the child of one of my fathers. And because of that, one of my fathers was deprived of all rights to custody and decision-making authority on my behalf. And, I was lucky to be able to testify in the legislature about my experience and my dad's experience, and also about the message that outdated parentage law sends to families like mine. What the We Care Coalition has accomplished with Polly and Doug's leadership and the force of so many other community leaders with this law means so much to me and to my brothers and to my dads. And I know how much it will make a difference today for families in Connecticut. So with that, why don't we find out how exactly things will change because of the CPA? Doug, can you give us an overview of the law just to set us up?
Yeah, so you're going to see a slide appear on the screen for everyone. We're going to toggle back and forth with slides. So the first slide is telling us the various paths to parentage that are available to individuals in Connecticut when the law goes into effect. The effective date of the law is January 1st, 2022. And we will talk about two sections of the law that don't go into effect until July 1st, 2022. What we wanted to do is just start off by giving a sense of the major paths to parentage that are available. Is the slide showing? Okay, so these are the paths to parentage that will exist in Connecticut in 2022. Adoption, which has been a path to parentage, especially for non-biological parents in the state, will continue to be available to people and is unchanged by the Parentage Act. So there might be situations in which people who otherwise would be adopting their own children might no longer do so because of the Parentage Act. The adoption statutes themselves are no longer changed, are not changed by the law. Giving birth is still a way to establish parentage, and consistent with existing Connecticut law, if you're giving birth pursuant to a surrogacy arrangement, then that is not a basis for establishing parentage. And we'll speak a little bit more about surrogacy. Genetics continues to be a basis to establish parentage, though it's important to note that a sperm or egg donor cannot rely on genetics to establish parentage. The presumptions of parentage, Polly's going to speak more about this, but there's a marital presumption of parentage, which we've had in Connecticut for decades, but we are adding to this a non-marital presumption of parentage, one that has been instrumental in other states to helping LGBTQ parents. De facto parentage, this is the provision that won't go into effect until July 1st of 2022. And we'll talk much more about de facto parentage, which is a pathway for non-biological, non-adoptive parents who weren't in the child's life at birth, but eventually are in the child's life and parent the child. And then intended parents, both through surrogacy arrangements and through non-surrogacy assisted reproduction. And those two things get treated differently in the Parentage Act, which we'll discuss. If you go to the next slide, you'll see that we just wanted to make people aware that while there's these pathways to parentage, there's then steps that individuals might take to establish parentage. But one thing to note from the outset is that the law, very comprehensive law, makes individuals in various circumstances parents of their children just by the operation of that law. Meaning that you don't necessarily, in some circumstances, need to go to a court or sign an acknowledgement in order to be treated as a legal parent of your child. There are some situations, which we'll discuss, that require that you get an adjudication from a court to establish parentage, such as de facto parentage, or that you sign an acknowledgement of parentage. For instance, if you are a presumed parent under the non-marital presumption, and that is required in order to establish parentage. But there are many other situations in which you are not required to do so, but people in the community will access parentage through acknowledgements or adjudication in order to really secure their parent-child relationship. So some of what we'll talk about today is the kinds of things people will do in order to have real assurance that their parent-child relationship is legally protected.
Great. Well, why don't we kind of dig into what these pathways actually look like in practice, because they can be kind of complicated. Polly, what is a presumed parent and how does the law affect that?
Great, of course. And I think before I jump into presumed parents, I think it's worth pointing out that some people in the community might fit into multiple categories of parentage, right? Which I think is one of the benefits of the law is that there are some options and some overlap, which expands people's access to parentage. So if we could move on to the next slide, that would be super. So as Doug mentioned, there's provisions in the statute to clarify and bring to Connecticut a new provision, which is a non-marital presumption of parentage. So here's the presumptions. So there's a marital presumption of parentage, which is, a presumption that we all know well. And as Doug mentioned, so when a married person gives birth, their spouse is going to be presumed to be a parent. That's by operation of law. You don't have to do anything. You just have to have a child during your marriage, and your spouse is going to go on the birth certificate. And we'll talk a little bit more in a minute about what additional protections married people might want to take in order to be protected in all jurisdictions. But the marital presumption continues under this law and remains an important protection for children. And the law also brings into play the non-marital presumption, which says effectively a non-marital parent, presumed parent, is someone who, together with another parent, the other parent resides with the child and openly holds the child out as their child from the time of birth or from the time of adoption for at least 2 years. And that is a presumption that needs to be kind of perfected, or you need to do a little extra to bring that from a presumption to legal protection. So you need to sign either a voluntary acknowledgement or obtain a judgment of parentage, in which we'll talk about voluntary acknowledgments or acknowledgments of parentage in Connecticut in a minute. So those are the two presumptions. I will also mention too that a child is presumed to be the parent of two people, also within, if they're born within 300 days of a marriage ending. So 300 days after divorce, for example. So it's also important to be aware of that. So that's a little bit about presumptions, which will again apply to a number of people in the LGBTQ community.
Great. And so there are some presumed parents, but you also mentioned intended parents. What are intended parents and how does the CPA affect them, Doug?
Yeah, so we can move to the next slide. And here I'm going to be talking about intended parents through assisted reproduction other than surrogacy. So use of donor insemination or IVF, where the birth parent is also an intended parent. And as Polly mentioned, many people will be satisfy multiple categories of parentage. So if you have a married same-sex couple and one individual is the birth parent and the other is the non-birth parent, the non-birth parent will be a presumed parent, but if they're having a child through assisted reproduction, that person will also be an intended parent. And so an intended parent is an individual who consents to assisted reproduction with the intent to be a parent of the child. And that's, of course, very common for same-sex couples and LGBTQ parents in Connecticut, as well as many other individuals in Connecticut. And Connecticut has the second highest rate of assisted reproduction in the country. The assisted reproduction provisions in the Connecticut Parentage Act update the statutes in Connecticut so that they are marital status neutral and gender neutral. So previously, Connecticut law only provided for situations involving a husband and wife. And so now the law basically just uses the term individual to say the individual who consents to assisted reproduction with the intent to be a parent is treated as a parent. This is one of the places where I said by operation of law, someone would be treated as a parent, but also one in which people are very likely to do things to actually secure their legal parentage. Parentage orders relating to assisted reproduction are going to be going to the probate court in Connecticut, not to the family division of the Superior Court. And so individuals may go into the probate court, can do so before the birth of the child to obtain a judgment of parentage that makes clear that the intended parents are the legal parents of the child. In order to be treated as an intended parent, there has to be evidence of the shared intent that you're both parents. The law prefers that there be consent in writing, evidencing that the person is an intended parent, but it does not require that there be a written consent. And so other evidence of an agreement that the birth parent and the non-birth parent would be the intended parents of the child would suffice if there is not a written agreement to co-parent the child. The probate court is preparing forms that will be available to people for these situations to be able, they'll be ready January 1, 2022 to go into probate court and seek judgments of parentage. But one thing we want to also be clear about is that intended parents can also establish their parentage through an acknowledgement. So if we move to the next slide, Polly and I are going to speak a bit about acknowledgments of parentage. So acknowledgments of parentage can, so just to be clear, we have acknowledgments in Connecticut right now. And in fact, we're required to do so by federal law, but these are called acknowledgments of paternity. They are issued and maintained by the Department of Public Health, and they are only available currently to different sex couples. This is the most common way that unmarried birth parents establish parentage for the father in Connecticut and around the country. And the important thing about acknowledgments of parentage is that under federal law, other states are required to give them what we call full faith and credit, to treat them as valid and respect them. So what our law does is, come January 1, the Department of Public Health will have acknowledgments of parentage that are available not only to genetic fathers in different sex couples, but also to presumed parents and intended parents who engaged in assisted reproduction other than surrogacy. And so now many same-sex couples in Connecticut will be able to sign an acknowledgement of parentage with the birth parent and the intended parent or presumed parent to establish that person's parentage. Acknowledgements required by federal law have the force of a judgment of a court. One thing to be very clear about is that it's not like signing any form of paper. Once you sign an acknowledgement, you have 60 days to take it back, and you have to follow a process to do that. And if you don't, it can only be undone upon a very difficult showing that there was fraud or some material mistake of fact. This is required by federal law as well, because we like to have finality with these acknowledgements that are equivalent to judgments. And so individuals should be very clear that they intend to be establishing parentage before they actually sign an acknowledgement of parentage. Polly's going to talk more about the nitty-gritty of acknowledgements so that people have a sense of what to expect come January 1.
Yeah, I have to say, I think the acknowledgments of parentage is, for me, one of the most exciting pieces of this new bill, because one of the goals of the law is really to make sure that families can protect their children as close to birth as possible and with as few barriers as possible. And this voluntary form, which is a weighty form to sign, means that for most families, for many families in our community, they'll be able to protect their children at birth. So here's the nitty-gritty. Right? If you are a family, let's take a lesbian family, parents who are going to have a child in a Connecticut hospital, and you've conceived the child through assisted reproduction, could be using known donor sperm, not unknown donor sperm, but conceived through assisted reproduction. When your child's born in the hospital, one of the documents that you can request, along with, you'll be given the Social Security forms to sign your child up for a Social Security number. You'll be given various birth certificate paperwork, and you also should ask for a voluntary acknowledgement of parentage form. And that form, again, will be accessible. So if you're a married couple, you can sign that form, or if you're an unmarried couple, you can sign the form. And that will be your kind of equivalent of a legal decree of parentage. And for unmarried parents, that form will then inform the birth certificate, and both of those people's names will appear on the birth certificate. For married couples, by virtue of your marriage, you will already be listed both on your child's birth certificate. So for people who are planning to deliver after January 1, 2022, this form should be available in hospitals. And I will say, in other states, I've had the pleasure of being involved in training hospital workers. We've reached out to the Department of Health to kind of offer our assistance in that process in Connecticut. And we have every expectation that that will be smooth. But after January 1, 2022, if folks have any issues or encounter any issues accessing forms in hospitals, please do contact us. Reach out to Glad Answers, because many times trainings are also helpful after a law has gone into effect to make sure that any blips are addressed with staff. And then Oh, for people who might have older children, but who might have been born into a non-marital relationship and only one parent's the legal parent, you can also sign a voluntary acknowledgement for your child who's older, right? So outside of the hospital. And you can do that by going to the Department of Public Health or going to a local DSS office. So I just want to say that obviously this is all after January 1st, 2022, this form will be available, but it should be of great practical help. And again, as Doug said, it does have the force of a decree of parentage. Now, some folks might say, we get this question often, do I also need to then do a co-parent adoption? I think the benefit for us, you know, that federal law requirement that valid acknowledgements have the force of an adjudication and that should receive full faith and credit is a really powerful protection. Some people might also want to do a co-parent adoption to have an adoption decree. And that's really an individual decision. You should seek individual legal support and advice to walk through for your family what makes the most sense. But again, for many people, a voluntary acknowledgement of parentage is going to provide that security. Doug, I don't know if you wanted to add anything to that.
No, I was just going to add one little thing on something you mentioned, Polly, which is if folks already have a child and they want to use an acknowledgement of parentage, and I know we have many people who testified in support of the act who are in this situation, have not done an adoption and want to take advantage of the acknowledgement come January 1, you can contact the Department of Public Health or go to one of the satellite offices of the Department of Social Services. There are 10 or so offices around the state, so there should be one closer to you. And if you go to the Department of Health website and look at the information for acknowledgements, you will find a link to information about the satellite offices of DSS. The reason that these forms are not so readily available is because they do establish your parentage and have the force of a judgment from a court. And so you can't just get the forms online. You need to actually interface with someone representing the state in order to get the forms and the necessary instructions that go along with the form that the state is required to give you before there's signing of the form. Hospital staff are essentially deputized to do this work, but if you're not in the hospital giving birth, then you'd need to seek out the form. You should also note that forms can be completed before birth of the child, even if you don't actually execute the form until the child is born. And so people can prepare by asking the hospital staff for an acknowledgement. Again, if people are struggling to do this come January 1, you should let us know so that we can try to smooth implementation of the law.
Thank you both so much for that information. And if viewers have any follow-up questions, please don't hesitate to add them to the chat box and I'll ask them. Doug, I'd like to ask about another common family form that has not always been recognized by the law. If an individual has been parenting a child, but they are not the biological parent, is this person legally a parent?
Yeah, so can we put up the next slide, which is on de facto parents? So this is what other jurisdictions and now Connecticut will call de facto parentage. De facto parentage describes an individual, as Melina suggested, who wasn't a parent of the child and in the child's life at birth of the child, but has become a parent of that child. It's not a biological parent, but has been parenting that child, and the child understands that person as their parent as well. We have on the slide a picture of one of the wonderful families that testified in support of the act, Stephanie and Denise, and their daughter Dasani and their son Javen. Javen is Stephanie's biological child, and Denise came into Javen's life when Javen was 3 and has been raising him since that time. And Javen views both Denise and Stephanie as his parents. Under existing Connecticut law, there was not a way for Denise to establish parentage with respect to Javen. But what the de facto parent provisions are trying to do is to recognize people in a situation like Denise and Javen have a parent-child relationship, and they should have access, if they like, to establishing that parent-child relationship. And so de facto parentage is the way to do that. de facto parentage is not an easy standard to satisfy. So we want to be clear about this. So if we move to the next slide, you see on here the 7 requirements that are necessary to establish de facto parentage. Let me say a few things before I talk about them. 1, these provisions, again, do not go into effect until July 1st, 2022. The Superior Court wanted more time to prepare for de facto parentage, since it is a brand new cause of action in Connecticut. Petitions for de facto parentage can only be filed by the individual seeking to establish parentage, the de facto parent. And petitions for de facto parentage must be filed while both the child and the de facto parent are alive, and while the child is 18 or under 18. Petitions for de facto parentage can only be filed in the family division of the Superior Court. So there are constraints around de facto parentage petitions that don't exist for some of the other avenues for establishing parentage. The person then needs to show, by what we call clear and convincing evidence, which is a heightened evidentiary standard, that they resided with the child as a member of the child's household for at least a year, unless the court finds good cause to accept a period shorter than a year, that they engaged in consistent caretaking of the child, which you can think of as doing the things that parents ordinarily do to care for their children, like feeding and clothing and bathing and taking children to doctor's appointments, that they undertook full and permanent responsibility of a parent without expectation of financial compensation. In other words, they're not a child care provider who is being compensated to care for the child. Instead, they are actually taking financial responsibility for the child. That they held the child out as their child. People understood the person as a parent of the child. That they established a bonded and dependent relationship with the child that's parental in nature. Again, this is the parental in nature language this is a relationship that we would ordinarily understand as the kind of relationship parents and children have. That another parent of the child fostered or supported that bonded and dependent relationship. So with Stephanie and Denise's situation, Denise came into the family and became a mother to Jabin with the support of Jabin's other mother, Stephanie. And so that's an important thing to show in these petitions. And finally, that continuing the relationship between the person who's saying they're a de facto parent and the child is in the best interest of the child. And if the person actually is a parent of the child, it's ordinarily in the child's best interest to maintain that important relationship. And so this allows the person to get an adjudication that they are a parent. De facto parentage requires an adjudication. This is one of the areas where you can't sign an acknowledgement. It's not simply by operation of law. You must actually get an adjudication in order to establish your parentage. Again, we're not going to offer any individualized legal advice in this setting, so people might have questions about the specifics of de facto parentage and how to file a petition and what to expect that are best directed to an attorney. And if folks need referrals, GLAD has resources to get people to referrals.
Thank you so much, Doug. Polly, as you know, I was born through surrogacy. I was wondering if you could tell us about how the law affects families like mine. You're muted.
It's not a webinar if someone's not muted. We've hit it. So I just want to say, I mean, Connecticut has had the luck and, well, through very hard work of many advocates, including some on this webinar, of having surrogacy in place since approximately 2011. So Connecticut had gestational surrogacy, was accessible to families. What the Connecticut Parentage Act does is really provide greater guidance and guidelines for surrogacy and also expand surrogacy in a certain way. So let me walk you through that. So the law provides that there's now 2 ways that families can create their families through surrogacy. One is through gestational surrogacy, where the person acting as a surrogate is not genetically related to the child, and also genetic surrogacy, where the person acting as a surrogate is related to the child genetically. So there's now 2 paths to surrogacy in Connecticut, and the law provides guidance for how, all people in that sorry for my phone, all people in that situation can be protected in that process. For instance, some of the requirements of the law are everyone has to be 21 years and older. One party has to be a resident of Connecticut. Everybody has to be represented by independent legal counsel. So the law provides a number of provisions that are really intended to protect people involved in the process, have a planful process, and also establish the parentage of the intended parents at birth, so that the child from day one is secured to the intended parents for their life moving forward. I'm not going to go into, obviously there's many provisions in the bill about surrogacy. I think that they're relatively complicated, but incredibly important. I think that for people who are going to build their families through surrogacy, it's a great idea to consult with surrogacy practitioners in Connecticut to really get legal support and guidance from the outset.
Thank you so much, Polly. So with that, why don't we go to the questions that have been submitted in advance? One question is, will the Parentage Act be accepted and honored in all states?
Well, Doug, obviously, let's both jump in on this, but here's what I will say. So parentage is a product of state law, right? So the wonderful thing about the Connecticut Parentage Act is it's now laying out all the different paths to legal parentage. So if you're a legal parent under Connecticut state law, you really should be recognized as a legal parent in all jurisdictions. And particularly for LGBTQ couples, they're going to kind of want the equivalent of a court decree, right? So that every state, through the concept of full faith and credit, will recognize that person's parentage. And that's where this law really provides so many options for families, right? You can have an adjudication through courts. You can sign a voluntary acknowledgement for many people, which is the equivalent of a court decree. And you can still pursue a co-parent adoption. So this law provides many different pathways for people to get that decree that will give them protection throughout the United States. And Doug, do you want to jump in and add anything on that?
I just to agree with that. And again, as Polly mentioned, folks might want to speak with an attorney about whether they want the extra security of a co-parent adoption, but judgments of parentage and acknowledgments of parentage should be respected and treated as valid by other jurisdictions. And so the really wonderful thing about the Parentage Act is that it makes it much easier for LGBTQ parents and others who are using assisted reproduction or are non-biological parents to have that security in a straightforward and relatively inexpensive way.
And a related question to that is, what about international travel or moving to a different country? Are you all familiar with the law around that?
So again, I would just say that legal decrees of parentage are treated as valid as one travels. And so while there are treaties involving inter-country recognition of adoptions, and there isn't such a treaty around parentage judgments. Generally, judgments of parentage should be treated as valid by another jurisdiction and provide the security of a parent-child relationship. But again, I would, if you have particular jurisdictions in mind, should be consulting with an attorney who would be able to advise on the law of that jurisdiction.
Great. And we have a couple questions about more of the hospital details. What is the process when a same-sex female couple gives birth at the hospital? How have Connecticut hospital staff been trained on this?
Well, I talked a little bit about this when I talked about acknowledgments of parentage, but I think it's worth going back to. So on the training piece, we have reached out to the Department of Public Health to discuss training and kind of the rollout for forms. Very confident that that's going to happen. I had the great luck of participating in Rhode Island's hospital trainings. Rhode Island rolled out the Uniform Parentage Act just last year, and there were 3 trainings for hospital workers, 2 prior to enactment of the effective date of the law, and then 1 afterwards when issues were coming up and people had questions because they were living with it, right? And so they went rounded back and trained again. So I think that I'm confident that hospital workers are going to be well prepared, and we've offered our support in that process. And if for some reason people encounter issues from well-meaning hospital workers, we definitely want to hear about them, because I think in my experience, state agencies are really receptive to feedback, particularly when, people are, the importance of bringing a child into the world, right? It's a vulnerable time and they want to support families and they want to support families to succeed. So we will give them that feedback. And then, in your hospital process, like there's usually a number of there's a lot of paperwork that families fill out. And in that paperwork, if it's not already in there, families should certainly say, I need an acknowledgement of parentage form, right? And they should be given that form, have the instructions that go with that form, and fill that form out if that's right for their particular family. And again, if people are encountering issues or have questions, they can reach out to us, and we can walk them through that process as well.
And I'll just add that, one of the major hospitals in Connecticut, especially in the southern part of Connecticut, is Yale New Haven. And we have been in conversation with folks there, including the folks who run the acknowledgments program there. So they know this is coming and they are committed to making sure that people have access to acknowledgments, and we'll continue to offer to work with them as well so that large hospital chains in Connecticut are prepared. And Yale was particularly supportive of this legislation, and the chair of the OBGYN department there testified in support of the bill. So they're committed to actually making sure that implementation runs smoothly.
And I see someone asked in the chat, Melina, of what happens if the birth parent doesn't want to sign the acknowledgement form, right? I mean, sometimes at the hospital, there's one parent's not there. Sometimes there's a dispute between the parents. It could be that the other intended parent doesn't want to sign the form. Obviously, signing an acknowledgement of parentage is a voluntary process, right? That shouldn't be duress. If you voluntarily sign that form, that's wonderful. If you're a legal parent and someone's not signing the form, you obviously have recourse in the courts as well. So you can file an action to adjudicate your parentage depending on which path you have, right? If you're a consent to assisted reproduction, presumed parent. So there is always recourse to the courts if you feel, if you're a parent, you meet the standard and that form is not being signed. So there's a both and.
Can I ask, when should someone consult a lawyer in this process?
Oh, well, I hate to, I mean, I am a lawyer, so I guess I'm self-interested, but I think in general, I mean, one of the benefits of the bill is that, we're trying to make parentage as accessible as possible, right? Like so many people establish parentage in the country already through acknowledgments of parentage with no legal advice whatsoever, right? They're instructed by the state, they read the form, they have the form read to them, and they proceed to establish parentage. I think for LGBTQ families and people who are using assisted reproduction to create their families, or it's often really helpful to seek legal advice early on, right? Even in that planning process, to understand what are the different paths, what are my options, adoption, assisted reproduction, whatnot, so that you really know going in what you need to do to secure your parentage and avoid issues that come up later. I think it's really an ounce of prevention, really helps avoid disputes later on. Doug, do you want to add to that?
Yeah, I think that's right. I mean, if people are in a position to be able to make sure they're proactively protecting their families, then that's great. One thing we're really trying to do is that a lot of folks were trying to navigate the system on their own, and it's going to be a lot easier now and a lot more straightforward for people to establish parentage. As Polly said earlier as well, if you're thinking about surrogacy, you certainly should be consulting an attorney before you begin to go down that road. So, and there are healthcare providers in Connecticut who are the sort of leading providers of assisted reproduction, who also have particular attorneys that often are serving families that are working with those healthcare providers. And so we have professionals in the state, including some who are part of our coalition, who are expert in this and will be able to meet the needs of families in Connecticut who seek out legal services.
Thank you all. There's a question if kids can have more than two parents.
Yeah, so I could start here and Polly can weigh in. So, so the law provides that a court can adjudicate more than two parents for a child. What that means is a child can have more than two parents. It's not going to be a common scenario, but we do know that there are families in Connecticut in which a child really has more than two individuals who they have a parent-child relationship with. In order to be able to get to the stage where a court would be authorized to issue a judgment that says there is a third parent for this child, the third parent would have to satisfy one of the paths to parentage. So they are either an intended parent or they're a presumed parent or the de facto parent. And if that person is then found to satisfy that path to parentage, the court does not just automatically adjudicate them a parent. The law instructs the court that it should only do so if not finding that person to be a parent, a legal parent, would be detrimental to the child. And detrimental is a higher burden than best interest of the child. So there might be some scenarios in which there is a third person that satisfies parentage, but a court might think that it's not an appropriate situation to actually adjudicate that person a parent. But in situations in which there is a third parent and that relationship is an important relationship in the child's life, our law come January 1 will empower courts to recognize when a child really does have more than two parents. And that we think is really important for respecting families around the state.
Well, and I'll just add a kind of a plug for some standards that the LGBTQ legal movement put together a number of years ago, which I'm not sure if someone can put into the chat, but to say that regardless of whether the law protects more than two parents, which Doug so well explained, I think in our community where our families are so diverse and often made up of more than two parents or more than two adults that really have a significant role in a child's life, that it's really important to center the child and that make sure that if something goes wrong in that adult relationship, that the child's not the one who's separated from the adult or suffers, right? Because those parent-child relationships, those secure relationships for children are so important for their healthy development, and that we as a community want to really support children's relationships and not have them face the consequences of a breakdown of adult relationships. So anyway, I just want to put a plug in for that. Does a parenting plan and a divorce establish parentage? It's a really great question. I believe, Doug, the bill talks about that a decree of divorce that says a child is a child of the marriage does function as a decree of parentage.
That is correct.
Yeah.
So that is actually a path that I did not mention because it's very specific, but the law is specific that if there is a divorce decree that provides that a child is a child of the marriage, that constitutes a judgment of parentage such that the two individuals are the legal parents of the child.
Right.
Thank you. We have a last question. What if there are competing claims of parentage?
So I can speak briefly on this and Polly can weigh in as well. It's a great question. So let's say that there is a birth parent and then there's a spouse of the birth parent and a genetic parent who's not the spouse of the birth parent. And both of those individuals might have claims to parentage. The court under our law is given factors to consider in deciding how to adjudicate parentage in that scenario. Now, just to be clear, that scenario existed in Connecticut before, and our courts have been dealing with those scenarios, but without guidance as to how exactly they're supposed to make the determination. And so the Parentage Act, seeking of centering the child, instructs the court to make that determination in the best interest of the child using specific factors, which go to the importance of the relationship the child has with that individual, how long that relationship has been existing for the child, the bond that's been formed, so that really what the court is doing is protecting the child's important parent-child relationship, regardless of whether that person is the genetic parent of the child. And the court is authorized to make a determination that only one of those individuals is the legal parent, and that might happen in some cases. But the court is also authorized to adjudicate both individuals as parents if, as I mentioned, it finds that not doing so would be detrimental to the child. So there can be competing claims that result in a winner, one person's the parent, or there could be competing claims that actually result in both individuals being treated as parents in addition to the birth parent, such that there would be 3 parents of the child.
Agreed. Yeah, and I think that guidance is really helpful, right? And really helpful in clarifying that what's going to animate these decisions, hopefully, is really the child's relationship to the adult.
Right.
Well, seeing that we have no other questions, I'd like to thank you again, our tremendous panelists, our wonderful panelists, for speaking with us and sharing their knowledge and advocacy. I'd like to thank all of our viewers so much for coming. And of course, our interpreters on the call and the GLAD team who organized this. I'd also like to direct our viewers to various resources that will be linked in the chat. Again, if you have a specific situation for which you need to speak with an attorney, you can start with GLAD Answers, which is www.gladanswers.org for referrals. Again, and thank you all so much for coming. Keep an eye on the GLAD websites and the Yale CPA website for FAQs, and of course, be in touch if you have any questions. A round of applause to our panelists again.
Thank you, Melina. You're
Thank you, Melina.
fantastic.